For the rest of the day, we shall be listening to two presentations, the first by Sam Stein QC, the second by Karen Monaghan QC, on behalf of two of the smaller groups of core participants. First, though, Sam Stein QC, on behalf of those core participants represented by Milners.
The person who knows that the blood products that they supply contain a high risk of infecting another person with a disease, such as Hep B or C or HIV, commits the offence of inflicting grievous bodily harm. If the person does not immediately die, if the supplied person dies as a consequence, it is murder. Those who are part of the supply chain, when either supporting or assuring such a supply with the requisite knowledge of what they are doing, are guilty of conspiracy to murder. It is clear that those who are responsible for the criminal infection of people through the supply of contaminated blood should be prosecuted. Those people who wiped out thousands of haemophiliacs and other people should be made to pay for their crimes. In the United States, this scandal has been labelled the haemophilia Holocaust. In the UK, over 4,500 haemophiliacs were given HIV and hepatitis C by treatments provided on the NHS, of which approximately half have since died, and thousands more human lives have been destroyed. The haemophiliacs infected and killed died horribly, their lives made a sheer misery, their families broken and all too often also infected. The evidence discovered by campaigners suggests that state bodies, including the NHS, actively pursued human observation, testing and experimentation that was unthinkable in the wake of the development of the Nuremberg Code. With Alan Barker and instructed by Milners Solicitors, I appear on behalf of 4 core participants and a witness from the infected and affected haemophilia community. Through these opening submissions, we shall set out our representations as to how this inquiry should proceed in order to operate most effectively and to support the participation of infected and affected persons and achieve the objectives of this inquiry. Following this preliminary hearing, we will provide a copy of our speaking notes. We will also draft and file written submissions based and building on our oral submissions and provide comments on the proposed expert panel. The core participants we are privileged to represent have over decades campaigned for the protection and rights of infected haemophiliacs and all gave evidence to the Archer inquiry. They have devoted their time and, in the absence of any public funding, have invested significant financial resources to ensure that their fight was not forgotten. Peter Mossman, a haemophiliac infected with HCV in 1985, who, having previously been an active member of the Haemophilia Society Northwest, jointly formed the Manor House Group in 1994, and who has since played an important role in lobbying Parliament and protesting on behalf of infected haemophiliacs. Having left the Manor House Group, he today continues his campaign work despite significant health problems. Colette Wintle, a woman with haemophilia infected with hepatitis C in Scotland in 1976, hepatitis B in Kent in 1982, and again with hepatitis C at the Royal Free Hospital in London in 1985. Colette lost a career in nursing due to hepatitis B infection, but also subsequently lost her career in the airlines due to the sole fact that she was a haemophiliac. Colette was also exposed to VCJD in 1993. a fact that was shockingly withheld from her until 2004. Since 1994, she has actively researched and campaigned for justice. Colette's husband, Stephen Wintle, who has campaigned with her and on one occasion wore a necklace of blood bags around his neck outside of the Ministry of Health, who, other than working with her on her campaign work, also fulfills the role of her primary carer and works to provide for them both and their daughter. We also represent Carol Grayson, the sister-in-law of Stephen, a haemophiliac who died of HIV-HCV in 1986, and the widow of her haemophiliac husband, Peter Longstaff, who was also co-infected with HIV and hepatitis B and C and exposed to VCJD. Peter passed away in 2005. Following the death of her husband, Carol researched and wrote an acclaimed dissertation on contaminated blood in 2006. That dissertation critiqued the findings of the now discredited government report, Self-Sufficiency in Blood Products in England and Wales, from 1973 to 1991, published by the Department of Health in 2006. Her research revealed previously unpublished documents that had been allegedly destroyed or lost, which exposed glaring omissions and inaccuracies, whilst pointing towards a government-led cover-up. But let me not forget Matthew Johnson, a witness to this inquiry, a haemophiliac infected with Hep C and exposed to VCJD. For all four of our core participants, and undoubtedly all of those infected and affected by contaminated blood products, the gravity of this long overdue public inquiry cannot be underestimated. By 1991, the Minister for Health, Virginia Bottomley, had recognised what she termed the special status of haemophiliacs. This was because she appreciated that a haemophiliac sufferer in the 70s and 80s already faced a battle against a lifelong condition that adversely affected their health. It also affected schooling, employment, insurance, travel and mortgage prospects, amongst other restrictions. If they survived the fight against the condition, then these issues have been grossly exacerbated by infected blood. The recognition of the special status of haemophiliacs was also because haemophiliacs have often been infected with multiple viruses, and multiple members of their families have been infected and killed. The factor concentrates provided to haemophiliacs carried such a high risk of infection that even if you are lucky enough to avoid infection once, twice or more times, eventually with blood sometimes carrying a 50 to 70% chance of transmitting a disease, you are going to be infected. The fact that only about half of haemophiliacs who are exposed to infected blood are alive today speaks for itself. And over recent days, we have been reminded of the words of Lord Winston, who, in reference to the disastrous treatment of haemophiliacs, correctly asserted that this was the worst medical treatment disaster in the history of the NHS. So this inquiry is dealing with a double disaster of whole blood cases and what appears to be the targeting of the haemophiliac community. But both cases must be fully investigated by the inquiry. Now, sometimes the two groups will require different considerations, different experts and evidence. We suggest that always addressing the two groups together without careful thought will confuse the public's understanding of the issues. The different facts which apply to each group already confuses the media, with many stories having been published with incorrect or misleading facts. This is a disservice to both cases. The education and understanding of the public of the issues and medical conditions are fundamentally important, particularly considering the unjust stigmatisation, some words I'm poor with, and discrimination of the haemophiliac community in the past. Therefore, we ask that where it is possible, and where there are, sir, separate issues to be addressed, that haemophilia and whole blood issues are separated. We submit that dealing with the inquiry and these issues this way would also provide some assistance to the respective members of the groups in allowing them to believe and see that their issues are understood. It will have the advantage of allowing for a better ability for people to live and work and focus their attention on the parts of the inquiry for which they have the most concern. I turn now to paragraph 1 of the Terms of Reference, and the question that we suggest that there is a need to investigate from 1950 onwards, but this must be done in a proportionate and careful way. The Terms of Reference have provided a solid foundation for the inquiry to begin what will be a sizable task. However, noting that paragraph 1 of the Terms of Reference state that the inquiry will examine the circumstances in which men, women and children treated by the NHS in the UK were given infected blood and infected blood products in particular since 1970, we suggest that if the inquiry is to properly investigate what happened and why, the questions of precisely who knew what and when need to be answered. We believe that failing to adequately investigate what was known prior to 1970 would be a mistake. What we suggest is required, is a settled foundation or platform of what was known and what warnings there had been prior to 1970 about the danger of collecting blood from contaminated sources. It was recognised in the 1930s that a virus from a blood donor could be transmitted to a recipient of blood or blood products. The potential problem of hepatitis B began to be appreciated only shortly before World War II ended. During the Korean War of 1950 to 53, a plasma program that had been developed by the United States was discontinued because of the alarming percentage of hepatitis in service personnel who had received plasma infusions, especially where the plasma had been prepared from large pools. Outbreaks of hepatitis in haemophiliacs in the US, from first exposure to factor concentrates, are known to have occurred in the early 60s. Importantly, in 1966, the eminent American professor of surgery, J. Garrett Allen, published his findings in the peer-reviewed medical journal of surgical science and practice, the Annals of Surgery. He said this, that the most practical method of reducing the hazards of hepatitis B from blood is to stop using blood from prison, and the term he used, and also skid row donors. We therefore feel that it is essential that the inquiry covers the period prior to the introduction of factor concentrates to the UK in 1973, so as to properly establish what was known in relation to the dangers of Hep A, B, and the risk of pooling plasma and when it became known. We suggest that considering what we know had been identified by the end of the Korean War, that 1950 would be the most appropriate start date from which to determine what was already understood by 1970 onwards. The most effective and economical way for this to be done will be for the inquiry to provide a timeline or chronology of relevant dates and facts. There have already been timelines produced by campaigners which can assist. A detailed chronology showing the correspondence, the published research materials and warnings, the various media reports and investigations and correspondence charted against the known activities of companies producing and pooling the infected plasma and against the various medical and political pronouncements will provide this inquiry with a backbone of facts from which to draw its conclusions and make recommendations as to change. Of course, this timeline can only be populated, filled in by the inquiry, who will need to act as a gatekeeper for references to be included. And we will need to develop a system to differentiate hard facts and points from more debatable references. The handling of documents with this inquiry is going to be dealt with by a company called Relativity, using their systems. And the question of whether the documents held by this inquiry can be hyperlinked to the timeline should be considered. But in any event, each reference must be accompanied by the inquiry document reference term. We suggest that the use of a living and growing timeline will help the inquiry to come to the conclusions as to who knew what and when, and who was at fault. And where criminal actions have been found and identified, this inquiry must not hesitate to refer the matter to the DPP. Paragraph 3 of the Terms of Reference. We welcome paragraph 3 of the Terms of Reference and the commitment to examine what other diseases people may have been exposed to. It must be highlighted that haemophiliacs have been infected with HIV, the full range of hepatitis viruses, paravirus, and exposed to VCJD. The inquiry must utilise the latest expert research and analysis to establish what else infected blood has exposed the victims to and what medically can be done to help them. We invite the inquiry to specifically establish the number of haemophiliacs who have been exposed to VCJD. Examine how this compares proportionately with instances of exposure in those receiving whole blood transfusions, and whether there is any malign reason why exposure amongst haemophiliacs was proportionately greater. Sadly, it seems to us that we have not yet seen the full crisis of VCJD. Consent, paragraph 6 of the Terms of Reference. The inquiry will, of course, examine the issue of consent. The Nuremberg Code deals with consent to human experimentation. Paragraph 1. The voluntary consent from the Nuremberg Code states the voluntary consent of the human subject is absolutely essential. Reading onwards. This means that the person involved should have legal capacity to give consent, should be so situated as to be able to exercise free power of choice without the intervention of any element of force, fraud, deceit, duress, overreaching, or other ulterior form of constraint or coercion, and should have sufficient knowledge and comprehension of the elements of the subject matter involved so as to enable him to make an understanding and enlightened decision. The Hippocratic Oath for doctors, taken, or at least in theory held dear by doctors, states, "I will utterly reject harm and mischief." The least any patient should expect before undergoing any treatment, let alone experimental treatment, is to feel safe in the knowledge that they have been allowed to make an informed decision to undergo that treatment with the full knowledge of the potential risks and consequences of that treatment. The last thing any human being should become is an unwitting guinea pig or lab rat. But that is precisely what happened to haemophiliacs. The fact that haemophiliacs were targeted and used as unwitting test subjects was communicated in a letter discovered and preserved by Carol Grayson, dated the 11th of January 1982, to all Haemophilia Centre directors from the Oxford Haemophilia Centre. In a test of our technical ability, we will try and show the relevant passage on the screen if Henry upstairs can provide it. Now that reads, although initial production batches may have been tested for infectivity by injecting them into chimpanzees, it is unlikely that the manufacturers will be able to guarantee this form of quality control for all future batches. It is therefore very important to find out by studies in human beings to what extent the infectivity of the various concentrates has been reduced. The most clear-cut way of doing this is by administering those concentrates to patients requiring treatment who have not been previously exposed to large pool concentrates. Those patients are few in number, but a study along these lines is being carried out at Oxford to determine the infectivity of factor VIII concentrates produced by the Plasma Fractation Laboratory, Oxford, and Blood Products Laboratory, Elstree. This study shows that it is possible to demonstrate infectivity using quite small numbers of previously untreated patients. Truly, awfully shocking. Thank you, Henry. We now know that there was non-consensual testing of blood and organs of haemophiliacs, withholding of test results from patients who had been infected or exposed to disease who were being tested without their knowledge. There was destruction and withholding of medical records that evidenced what each individual had been tested and treated for, and the inaccurate recording of statistics, including deaths of haemophiliacs exposed to infected blood. Documents have been uncovered that provide evidence that government ministers gave their approval to the surveillance of haemophiliacs who have been infected with Hep C and HIV. There are identifiable conflicts of interest, particularly for doctors in the NHS, with decision-makers believed to have been on the payroll of pharmaceutical companies who are providing the NHS with infected blood products and funding research, all whilst maximising profit from the exploitation of haemophiliacs. This warrants specific interrogation and investigation, and any who benefited financially must be exposed. The clear, repeated and unacceptable breaches of the Nuremberg Code and the Hippocratic Oath must be fully investigated and those responsible identified and brought to justice. Yesterday, we witnessed an incredibly moving commemoration. So many people have died and so many people's lives have been lost. For the survivors, their lives have been devastated and entirely consumed. Chair, you stated yesterday that you want to put people at the heart of the inquiry, and that in order to do so, during the first 3 months and final period of the inquiry, you'll hear from the infected and affected. The inquiry needs to hear from those who have been so infected and so affected, and needs to hear the evidence they can provide about events which are central to the understanding of the facts that are crucial to the core of this inquiry. Other inquiries have allowed core participants to present what were called pen portraits, or as I prefer to call them, personal commemorations of people's lives and deaths. Within this inquiry, under the terms of reference, paragraph 4, page 3 onwards, the inquiry is committed to considering the impact of infection from blood or blood products on people who are affected and on partners, children, parents, families, carers, and others closer to them. As counsel to the inquiry, Ms Richards, Queen's Counsel, said yesterday, the inquiry is to consider all of the impact on people's lives. This aspect of the inquiry is very important, and the need to commemorate the lives lost and the parts of lives that have been wasted and rerouted through infection has an important impact on the inquiry's overall determination. The determination that we suggest that this is directed to is that this must never happen again. And secondly, that there must be, from that evidence, an accurate assessment of the extent and amount of financial support and compensation that should be considered in the future. So we need to think and address the question of how can this be best done, when, sir, as you pointed out, there is also a sad need to complete this inquiry in a timely fashion. What we ask is this, that real latitude is given to those giving evidence concerning the impact on their lives and the lives of those who have been lost, in order to properly present their evidence in this regard. To achieve this goal, we suggest that there will be a need to discuss the impact of the evidence, the impact section of the evidence, with counsel to the inquiry, the solicitors to the inquiry, and the need potentially to provide a presentation which might include evidence, of photographs, films, or documents to be shown on a screen. And so time will need to be provided at the beginning of any such evidence so that that can be dealt with properly and with dignity. Paragraph 9A of the Terms of Reference recognises that there is a real and identifiable issue as to the extent to which there have been willful attempts to conceal the truth of what was known and what has happened. We say that there was a systematic attempt to destroy evidence, avoid the truth, and thereby abdicate responsibility for the actions of the state and its representatives. We know that documents that ought to have been kept and stored in the National Archives have been destroyed or have gone missing. We know from the experience of Carol Grayson that she provided documents to the government to plug the gap in the archives that was said to be irretrievably lost, and that since then that the documents she provided have since been held out to be newly discovered. There will no doubt be other infected and infected persons who hold documents or copies of documents that have been destroyed or lost according to official records. Due to the distrust of the government and public bodies such as the NHS, there is understandably a deep sense of suspicion as to what will befall documents that are released to the inquiry. And this may give genuine cause to question whether to release those vital documents at all. This must be avoided, particularly if an accurate timeline is to be established so that we know who knew what and when. Therefore, we call on the inquiry to establish a documents protocol to ensure that original documents in the hands of survivors are not lost, and that in the spirit of openness and to fulfil the duty of candour for this inquiry, that there is a record made on copied documents and a referencing facility provided to ensure we know exactly who has produced each document to the inquiry and when. We will, of course, provide more detailed points in our written submissions setting out our proposals. The inquiry needs, when dealing with the question of core participant support, to ensure that there are discussions with core participants. Every effort must be made to ensure that the needs of infected and affected families are put first in this inquiry. And of course, this includes thought that must be given to the provision of support, childcare, and inquiry hearing days. Accessibility issues must be addressed, not only at the chosen venue for hearings, but also through the provision of IT equipment and continuing IT support to enable those that can't attend in person due to their health and who cannot otherwise afford such equipment are able to observe the inquiry hearings. We also need to recognise that when it comes to the provision of evidence, that video link systems may well be required. Paragraph 11 of the Terms of Reference deals with the question of interim recommendations. We welcome the specific scope for the inquiry to make interim recommendations, referred to in the Terms of Reference. We say it is entirely appropriate for the inquiry to make interim recommendations as soon as it possibly can, particularly considering the financial plight of infected and affected haemophiliacs and the fact that many have died waiting for this inquiry. The advantage of an inquiry that inevitably takes some time is that the lifespan of the inquiry can be used to both make interim recommendations and follow through those recommendations by considering how the recommendations are dealt with by the state through to action. Targets for interim recommendations would include compensation and the current support payment schemes. We ask that you, sir, reach out to government and request that they undertake through the DWP not to carry out any further reassessments of the England Infected Blood Support Scheme, EBIS, payments for the duration of this inquiry. In due course, we will seek a recommendation of benefits passporting for haemophiliacs in line with the recommendations made by the Archer inquiry. But there can be no good reason why the infected and affected should have to suffer the ignominy of having to jump through unnecessary procedural hoops to receive basic entitlements in what the final report of the Archer inquiry labelled an undeserved affront to their dignity. We suggest that the inquiry reviews, as part of its possible interim recommendations, the disparity in support payments made across the UK and the inadequacy in support, in particular, of support in England for widows and widowers. Acknowledgement should be made that after their loved ones were infected by the actions or inactions of the government, many gave up their careers or could only enjoy limited careers because of the need to care for their infected partners. As to current support payments and their assessment, there is a complete departure, in England through IBIS at least, from the principle at paragraph 3, page 13 of the 1991 settlement leading to the McFarland Trust, that payments under that scheme, and therefore its successor, IBIS, should be excluded from consideration in the assessment of social security or statutory benefits. We also need to resolve the current and gross unfairness of ongoing payments across the English and Scottish borders and across the sea to Ireland. We suggest that the factors which have led to these payment inequalities be the subject of a timetable for written submissions, responses, and a dedicated period set aside to hear representations to resolve these issues sooner rather than later and dealt with by interim recommendations. Given the urgency of the situation facing the infected and affected members of the haemophiliac community, we also seek a recommendation for the payment of compensation. We remind you of the important statements made in the final report of the Archer inquiry with regard to the duty of government. The very purpose of government is to protect its citizens, so far as possible, from life's vicissitudes and to afford them the best achievable quality of life. Where poverty is widespread, even though not universal, among a limited and readily defined category of citizens, and particularly where it is attributable to a specific misfortune, we believe that they are entitled to look to the government for redress. The government has an immediate duty to step up, protect its citizens, and to provide the financial recompense that infected and affected members of both groups deserve. In conclusion, it's obvious that the inquiry can't turn the clock back for the victims, but it must establish the truth behind this terrible atrocity. The medical profession must wake up to what has happened, and people must be treated with respect. Once this inquiry is complete, there must be an apology from the state which acknowledges all that has happened. Everyone needs to find some measure of peace from the knowledge, at least, belatedly, the state, through this inquiry, has thoroughly investigated this tragedy and made recommendations to ensure that nothing of the like ever happens again. Now, this inquiry has started over these 2 days with a real display of determination and goodwill. A film I remember many years ago described it as positive waves. Working with Peter, Colette, Stephen and Carol, we will all strive to support and, where required, sir, push the inquiry in the pursuit of its mandatory objectives. Finally, let us not forget that after Archer and Penrose, this for RCPs and for many others is the third inquiry into this disaster. That means, we suggest, that we must work together to make this the last inquiry. So those are our submissions.
Thank you very much indeed, Mr. Stein. Now for Ms. Karen Monaghan, Queen's Counsel, who represents the core participants who have instructed Hudgell Solicitors.
Thank you, sir. Yes, as you've said, my name is Karen Monaghan. I represent 4 core participants, along with Mr. Philip Dale and Ms. Cerilia Knight of Hudgell Solicitors. As in the case of others we've heard from today, This statement has not been prepared by the lawyers alone, but has been prepared together with our 4 clients. Our clients contracted HIV in the early 1980s through contaminated blood products used in the treatment of their haemophilia. At the time this diagnosis was revealed to each of them, one was a young boy, the others were young men. They were all later informed of infection with hepatitis C too. With the exception of the youngest, our clients have all been involved with the call for this inquiry, as well as with other support work in their community over many years. They are 4 friends and share a deep interest, not just in a rigorous investigation, but in particular in one that is alive to the equality and human rights implications of the decisions made before, during, and after this disaster, something I'll come back to in one moment. Their experiences, including those gained through their campaigning work, are such that they have now acquired considerable knowledge and experience and expertise in the matters that are to be the subject of this inquiry, and they want to deploy that expertise to assist this inquiry in its important work. Starting then, sir, with the first matter you raised yesterday, what are the issues of most importance to my clients? The principal questions that our clients want answered are simple. They want to establish once and for all what happened, when it happened, how it happened, why it happened, who was or is responsible, how have those affected and infected been supported since, and what are the continuing risks to those who have or may have been exposed to other infections, including VCJD. They also want the findings that emerge from this inquiry to underpin recommendations directed at ensuring that catastrophic events of the sort that happened here, by the transmission of pathogens and poisons through medical treatments, are never repeated. As a starting point, our clients consider that this inquiry will need to establish what system of pharmacovigilance existed at relevant times. The examination of the use of Factor VIII is critical to our clients. They need to know what formal systems existed to monitor its use and to have examined how, if at all, concerns about it were addressed. The inquiry must also ascertain what information was given to the blood transfusion service and to pharmaceutical companies, in particular in the period from July 16, 1982, the date from when, in all likelihood, it became clear, based on the available medical evidence, that people with haemophilia were at risk of contracting what later became known as HIV through blood products. So from the period commencing July 16, 1982, until the introduction of HIV testing and heat-treated Factor VIII. Documents which shed light on the understanding in government about this risk and what they were told about it by pharmaceutical companies must be disclosed. I'll come back to documents in due course. A crucial question, too, is whether there were incentives from pharmaceutical companies for doctors or the haemophilia centres to offload what were cheap and, in the event, infected products despite risks. Risks from Factor VIII usage appeared to have been decidedly played down. People with haemophilia were told that conceivable risk to health would be more serious if they didn't take Factor VIII. Factor VIII usage was then actively promoted. These matters need to be explored thoroughly. Since there was heavy reliance, too, on the experience of haemophilia doctors in monitoring the use of factor concentrates, it will also be important to explore existing records that depict the state of knowledge of treating doctors at the time. Were they aware of hepatitis risk or unknown pathogens in factor concentrates? Since factor VIII was very much seen as the wonder treatment by many haemophilia doctors, as indeed was alluded to yesterday, there's real concern by my clients that doctors may have felt inclined to ignore the risks or downplay them because of the benefits believed to derive from factor VIII. Our clients are also mindful that in the 1970s and 80s, there was government awareness of the need for UK self-sufficiency in blood and blood products, something again already referred to. Why then did the UK resort to commercially obtained sources overseas? This inquiry, our clients say, will need to unpack the government's actions and inactions that stymied efforts towards UK self-sufficiency, or unpick what Lord David Owen, Health Minister at the time, told the Archer inquiry was resistance in the department to go for self-sufficiency. He said he suspected that it was the deep financial pressure they were coming under in respect of the health service budget. My clients want those pressures to be unpicked and explored and for judgments to be made about them. There's evidence, for example, that in the Netherlands, early warning signs were heeded. They became self-sufficient, and in consequence, relatively few patients with haemophilia in the Netherlands contracted HIV as a result of infected blood products. It seems, too, that in the United Kingdom, an artificially high evidential bar was set, so legitimate concerns about risks related to factor VIII were regarded as insufficient to justify action. Our clients want to know why it took so long to identify and convey the actual risks of the transmission of HIV, for example. There was the infamous Haemofact leaflet that many of you will recall, which suggested that the risk of HIV infection for people with haemophilia was 1 in 1,000. Haemophilia doctors, blood transfusion services and the Department of Health seem to struggle to come to terms with and to communicate the grim reality of HIV infection to those who were regarded as innocent haemophilia victims. The difficulty in coming to terms with this seemed to trigger a strain of denialism in some doctors. For our clients, this raises questions of stigma and anti-gay prejudice and pathologising of gay men and intravenous drug users. The question has to be asked why such a high evidential bar was set by senior haemophilia doctors in identifying the risk of HIV transmission for their patients. Were they themselves unconsciously thinking of those with haemophilia as the innocents, unlike the guilty, the gay men, the intravenous drug users, those people with HIV who suffered the gross stigma and prejudice associated with HIV in the 1980s? What the government and the NHS ought to have done to remove the stigma associated with HIV status is a question that touches closely on the experiences of those people with haemophilia, those people who were infected by reason of their haemophilia, but it touches too upon the experiences of all of those who were diagnosed as HIV positive at the time, gay men and others with whom my clients have stood in solidarity over the years. Our clients then resist any narrative of haemophilia exceptionalism, as it's sometimes described. Their concern is for an inquiry that robustly asks and inquires into those matters that form the subject of the terms of reference for this inquiry. But they do not seek to distinguish themselves as more deserving of sympathy or of support than those who contracted HIV through sex, intravenous drug use, or otherwise. And the same is true of HCV. At the core of the grave misapprehension around risk, then, is an issue of equality. In the early 1980s, AIDS was considered the gay plague and associated with the perceived debauchery of gay men in New York and San Francisco. The tendency to ignore or underestimate the risk associated with the use of Factor VIII, effectively by requiring incontrovertible proof, often reflected, our clients say, a state of disbelief that haemophilia, the wonder drug for haemophilia, could actually be the purveyor of what was considered a gay plague. The extent to which this was a psychological blind spot that affected the approach to risk must be examined by this inquiry. And then there was after the diagnosis. There were long periods where there were few advances in the treatment of HIV and hepatitis C, and then periods of massive advancement. For HIV, there was huge progress, in particular between 1995 and 2000, when highly active antiretroviral therapy for HIV appeared, and in the case of hepatitis C, between 2014 and 2017, with direct-acting antiretrovirals. How quickly and how well was information about these advances and improvements made available to people co-infected with haemophilia, HIV and HCV? That's a question, too, that must be examined by this inquiry. My clients know that obtaining accurate information about infection was a massive problem for those infected by contaminated blood products. In addition, in the early 1980s, there was no provision for counselling following an HIV or hepatitis C positive diagnosis. HIV clinics were mainly populated by gay men, and hepatitis C clinics by intravenous drug users. The label of those who contracted HIV or hepatitis C as a result of their haemophilia as innocent victims didn't help with their integration into the broader HIV, Hep C positive community. Infected people who've survived often tell a story of having to educate themselves about their co-infections, and sometimes their doctors too, along with other healthcare providers. In the case of our clients, the process of self-education forced them to integrate into the wider HIV community, in particular among gay men and other at-risk groups. It's that experience, generally a very positive experience, which informs their approach to this inquiry. Respect for the dignity of all infected or affected by HIV and HCV. Some of our clients were tested for both HIV and HCV without their knowledge or consent, and like many others, were not even aware of the results for a time. In 1991, when the Hep C testing of people with haemophilia was conducted, many did not know that they'd been identified as non-A, non-B hepatitis positive, or the ramifications of their test results. Concerns about communication and the delivery of information are obviously relevant, both for the question of support, but also under the topic of consent as well. In scrutinising the support given to those infected or affected, the inquiry should also examine the indignities dumped upon those infected by the need to apply for discretionary payments or welfare benefits and then subject themselves to intrusive and sometimes demeaning questioning about their lives and the seriousness of the impact of their infections upon them. For our clients too, the shameful lack of transparency around these events is of great importance and must be robustly explored, with the reasons for that lack of transparency interrogated. The absence of candour and openness by the government and others, and frankly what our clients believe can only be viewed as a cover-up, must be examined, and again those responsible called to account. The question, why has government resisted efforts to find out what happened for so long, is an important one for our clients, and we say should be an important one for this inquiry. This requires rigorous scrutiny of claims of lost documents and public interest immunity, something I'll touch upon very shortly. As to the future, our clients see this inquiry as an opportunity to develop recommendations directed at better ensuring that not only do we have a system for protecting our blood supply, but also that there are safeguards against any future route for passing pathogens, including presently unknown pathogens, from one individual, cell or organ to another person in the case of treatment, while at the same time, and very importantly, not to be lost sight of, not inadvertently prohibiting the use of genetic treatments for conditions such as haemophilia. They see this inquiry too as an opportunity for re-examining policies, practices and procedures for the government handling, storing and crucially destroying of documents relating to matters of great controversy, in particular where the risks of litigation or political embarrassment loom large. Sir, yesterday you also said that you saw the opportunity for core participants to make opening statements as one that could assist you when deciding upon the shape of the inquiry, including the procedures to be adopted. On this, as a general approach, we invite the inquiry to adopt a human rights sensitive approach throughout. I've touched upon the equality issues as our clients see them, and in this context we envisage, for example, that it will be necessary to interrogate assumptions and presumptions about HIV and AIDS and hepatitis B and C, even though they may have been conventional thinking in the 70s and 80s. Care must be taken too, not to reinforce the stigma of HIV and AIDS through the discourse in this inquiry. It will be necessary too to ask what role the government thought its international obligations under the European Convention on Human Rights had to play throughout the period with which this inquiry is concerned. As you will know, sir, the state comprising all the state agencies was and is, as a matter of international law, under a duty to protect those known to be facing a real and immediate risk to their lives. And what of Article 8, which also as a matter of international law bound the state, and its guarantee of respect for private life, the family, human personality and dignity. As to dignity and this inquiry, in addition to the matters I've also raised, with the greatest of respect to everybody here, everybody who's touched by the events leading to this inquiry, for our clients, language is important. Our clients don't describe as haemophiliacs. They self-identify as human beings with haemophilia. Persons with haemophilia are not all they are. Further, and as to what our clients believe was clearly a cover-up, it's our clients' view that there must be an early demand of relevant government departments to identify which documents were in fact destroyed and describe the circumstances surrounding their destruction, to explain the basis upon which public interest immunity was sought to resist disclosure in previous civil litigation, provide the inquiry with a schedule of material, if any, that it contends or the government departments contends is non-disclosable by reason of public interest immunity or legal professional privilege, to explain their previous assertions that on the one hand documents were destroyed and on the other hand that those very same documents were non-disclosable by reason of public interest immunity. Did they? Did those documents, do they still exist or not? If not, why not? And if they do exist, why in the case of some did the relevant government departments say they did not? Further still, this inquiry should not be distracted by the purported justifications found in the oft-repeated claims that what was done was the very best at the time, and that ultimately more appropriate decisions and actions would not have made any difference in any event. As to the core participants, if this inquiry is to be effective and meet the aspirations of the core participants and others who've been infected or affected, it must be inclusive and allow for full and proper participation, something that's been touched upon by others today. You've set out your commitment, sir, again today to achieving this, and my clients have been very pleased to hear this. But that commitment does mean ensuring that advocates of the core participants have the chance to speak to them and to make inquiries on their behalf. It won't be enough, we say, to allow the core participants' representatives or walk-on parts, to allow them simply to pass post-it notes to counsel to the inquiry with suggested questions during examination of the most important witnesses. Core participants, through their representatives or by themselves where they're unrepresented, must be permitted to ask questions that they want to ask in the way that they want to ask them, and trust must be invested in them by the inquiry that they will do so responsibly, fairly and proportionately. Finally, as you've said, sir, the infected and affected must be at the forefront of this inquiry. To that end, I would like to finish our contribution today by reading an extract from a statement made by one of our clients and then make a short comment. He says this about first being informed of his diagnosis of HIV, contracted through treatment for his haemophilia. I was called into an office at the Royal Free Hospital in 1984-5-6 while attending a routine appointment for my bleeding disorder. In this room, I was told my medical treatment had infected me with the AIDS virus, for which there was no treatment, no cure, and no prognosis, other than that everyone else who'd been infected died a horrible, slow, and painful death within 2 to 3 years of infection. I must have asked all sorts of questions. How long have I got? When will I become ill? Will there ever be a cure? None of them could be answered, and the only piece of advice I remember being told is to either not have sex, or if I really had to, then to use 2 condoms. I'll never forget walking up to Pond Street to the nearest pub, buying a pint and writing my will. So the spectre of death is a common theme in the stories of those infected and affected by this scandal. Many who campaigned for an inquiry are no longer with us. Those who remain, including our clients, bear no undiluted sense of triumph that this public inquiry is now a reality. They take comfort, however, from your commitment, sir, and the commitment of your legal team to getting it right this time. They truly hope now for justice.
Well, ladies and gentlemen, that concludes the proceedings for today. We start again at 10 o'clock tomorrow morning sharp, and I look forward to seeing you then.